We are truly blessed with the love and commitment we share, and for this we give gratitude to you, beloved Creator. We have found our others and still are, as we walk this leg of our journey, each and together. We give thanks for the seeming synchronicities that come along to help us on our way. We have gratitude for the love that makes room for discernment without judgment and allows for differences. And where there is joy and harmony always, we thank you. Please that we continue to walk with you, you who set us in motion. Head us in the right direction, that we can make the difference for all our focus and commitment to what we believe is a higher pathway. Keep our hearts open and our thoughts and feelings high, that we may continue all that we do with right purpose and attraction for all that is good and righteous. Let it be so. So it is.
Amen.
Thank you, Charlie. Amen.
You're welcome.
So what I wanted to do, this thought occurred to me, and I hadn't looked it up yet, and I wanted to do this, and I thought, oh, right now would be a good time because we're all here. I want us to look up the word counsel. And I bet this
What kind of counsel? SEL or CIL?
COUNSEL.
SEL. So like legal counsel or
Law. Well, that's the
mental
point.
counsel or whatever it might
Counsel.
be.
Just counsel, not legal lawful. I want to look at the definition of counsel and how it might have been changed through the years, because we have been denied, our people have been denied counsel if we don't have a BAR number.
That's happened to Mike down in California too.
Like school. Okay. Because I think counsel has been changed by the bar to mean a very different thing than what it was intended by our founding fathers. So
Well, we just keep inserting ourselves. That's the best we can do, right? You just keep trying to throw a monkey wrench into the machinery.
Well, yes, but this is key in terms of how we do it, because by definitions and how they've altered the definitions.
I have it.
Okay, I have I have it, but I haven't got just a generic one. Okay, I've got it. So I'm going to read, I have the newest edition. So I'm going to read my edition first, and then we're going to go back in time. And Cynthia, you'll read yours last, because I think yours is going to have the most accurate definition of what it was intended to be. Okay?
Okay, so what edition is yours?
Mine is 11.
And Ron, yours is?
6, right?
Yeah. And I have
or
5.
7? 6 or 7? 6. Yeah, 6. And yours is what?
7. I mean 5.
5, yeah.
I have 5.
Yeah. Okay, so mine says, and it's counsel, COUNSEL 13C. What does 13C mean? Is that 13th century? What is that? In parens. Okay. Advice or assistance. Opinion given as the result of consultation, and then it has a caret. The lawyer's counsel was to petition immediately for a change of immigration status. End of caret. Number 2, one or more lawyers who, having the authority to do so, give advice about legal matters, especially a courtroom advocate. Caret. The client acted on advice of counsel. End caret. In the singular, also termed counsellor with one LOR, counselor at law, attorney, lawyer. Number 3, English law, a member of the bar, barrister. And that's it. And then it has all kinds of counsel listed after that. It goes advisory counsel, amicus counsel, appellate counsel, appointed counsel, assigned counsel, class counsel, corporate counsel, corporation counsel, counsel amicus curiae, counsel of record, court appointed counsel, And then it has stuff under that: duty counsel, general counsel, house counsel, independent counsel, in-house counsel, inside counsel, junior counsel, king's counsel, lead counsel, good heavens, local
Lord.
counsel, of counsel. That's it. Wow. Okay.
Yes, wow.
Doesn't have any of that stuff in there.
I don't have any of that stuff either.
Yeah.
Mine goes counsel, SEL,
What's
attorney,
SEL? What is that?
Just COUNSEL and not
Oh, I see.
COUNC.
Okay, got it. Yeah. Okay,
Okay.
go ahead.
and it says attorney or counselor with SELLOR. And then it's got a QV in parentheses, which I don't know what that means either.
Me neither.
And it says advice or assistance given to one person to another in regard to a legal matter, proposed line of conduct, claim, or contention. See also counsel. To write. Then we have legislative counsel, counselor, SELLOR. Then I have counsel of record and counsel right to, and then I'm done.
Wow. Okay, Cynthia, you're on.
Okay,
We want to do a show on this, you guys.
okay.
Good.
So mine counsel, attorney or counselor, and again, like Ron, mine's got QV after it. And I don't know, it's in parentheses, Q period, V period, smaller caps. Advice and assistance given by one person to another in regard to a legal matter, proposed line of conduct, claim, or condition. The words counsel and advice may be and frequently are used in criminal law to describe the offense of a person who not actually doing the felonious act by his will and contributed to it or procured it to be done. See aid and abet. See also legislative counsel of counsel, junior counsel. This is all part of my counsel. Junior counsel, the younger of the counsel employed on the same side of a case, or the one lower in standing or rank, or who is entrusted with the less important parts of the preparation or trial of the cause.
Interesting, yeah. Brandon, thank you for that. And I was looking it up too. So Q.V. and it's pronounced QV, used in books to tell a reader that there is more information in another part of the book. It's from Latin, quod vide,
Oh,
QUODVIDE.
Yes, thank you.
Mm-hmm. Yep.
yeah, because of counsel is something else that it refers to, like to go to. Like there must be something in this Black's Law of counsel, OFCOUNSEL.
Yes, Ron. Yeah, thanks, Cynthia. Ron.
Counselor, an attorney, semicolon, lawyer, period. Member of the legal profession who gives legal advice and handles the legal affairs of a client, including, if necessary, appearing on his or her behalf in criminal, civil, or administrative actions and proceedings.
Okay, I have counselor. Mine is a lawyer, one who, having the authority to do so, gives advice about legal matters, especially a courtroom advocate, also spelled in BRL. I don't know what that is, British, or BRE, British English maybe, and in pre-1920 AM, capital A, American English, yeah, AE sources, counselor, COUNSELLER. So they spell it both ways. So in this definition, it is a lawyer. one who has having the authority to do so, gives advice about legal matters, especially a courtroom advocate. So what does yours say, Cynthia, about counselor?
Mine says the same thing as Ron's, but then I drop down to counsel of record, attorney whose appearance has been filed with court papers. And then counsel, comma, right to. Constitutional right of criminal defendant to court-appointed attorney if he is financially unable to retain private counsel, guaranteed by 6th and 14th Amendments to U.S. Constitution, and as well by court rule. So does
When was-
anybody have the first, it goes on, I'm not going to read it.
No, when was yours published, your book?
Yeah, I want to know, does anybody have the number 1 when Black's Law first came out?
Ron. Ron
Ron
raised,
does?
Ron,
Tanya's hands up.
okay, hi, Tanya, go ahead. You need to unmute. You need to unmute. Can't hear you, Tanya.
Mine says 1860 to 1927.
Hold on a second here, it's me.
Oh, hi.
Oh,
Hi, William.
1891 was the first time mine was written. 1891.
Go ahead, William.
I'm waiting for Ron to get back on his
Oh,
headset.
okay. Oh, okay, all right.
Being here is to be waste, right?
Yeah. Who said that?
1891.
All right,
that-
so I want to comment on this council thing.
Yeah,
Remember the red folder that we got?
yes,
In the red folder, I recall you would be in court, God forbid, right? But you're there and you're in there, you didn't hire a damn attorney, you don't have one or whatever, right?
right. You're
'Cause you
talking
don't
about
want-
this,
Yeah, because you don't want one, right?
right?
And you tell the judge, from what I remember, I don't have it in front of me. You tell the judge, I'm without counsel, right?
Right,
And then he has to appoint you counsel.
right,
So then he appoints you an attorney, a bar attorney. So
right,
and then you take the documents inside the folder and you make him fill out those damn documents and tell him what to fucking do. And if he doesn't do it, you fire his ass right there in the middle of the goddamn courtroom and tell the judge you're without counsel again. You just keep repeat, watch,
right. Yeah, this is what you're talking about. This is a form, actually. Memorandum in support of request for assistance of unfettered counsel.
There you go.
Ron,
Unfettered is so well said.
yes.
Counsel, 1891, Counsel 1, in practice, an advocate, a counselor, SELLOR, or pleader. Absolutely nothing about attorney, nothing about lawyer.
Mhm.
There we go.
One
So the
who
bar-
assists one who assists his client with advice and pleads for him in open court. Counselor, who are
Okay.
associated with those regularly retained in a cause, either for the purpose of advising as to the points of law involved, or preparing the case on its legal side, or arguing the question of law in court, or preparing or conducting the case in its appearance before an appellate tribunal, are said to be of counsel.
Very
I
good.
yield.
Thank you, Ron. What, pardon?
I want to know when it changed from the original Black's Law, the first edition, to when it changed to attorneys and lawyers, because by the 5th edition, which is mine, it still says attorneys and lawyers.
And then
Okay, so we
Ron's
need
the
to know the
third.
definition also, right, of lawyer. Because my definition of lawyer means somebody that studies law, which is every one of us in this group right here.
That's right. So what edition do you have, William?
I don't have one.
He's just
Okay.
saying his definition of lawyer.
Fine.
Yeah,
So
Fine.
well,
he-
okay,
How
so,
I understand it, right?
Yeah, okay, so, so I think, first of all, let's do this with the definition of counselor. We're gonna be able to use this in our pleadings for our people. So,
The reason why I say that is because in the word lawyer, it means law study.
yeah, they're not called
Right?
leaguers.
So change the definition of that word when it's in the word.
Right, that's right. Yeah, so, good point, William. This is another example of color of law. I want it
Yes,
to be so that it's in the face of those who are saying we're not counsel, and we're going to say, yes, we are. We are, but you are color of law, and you're rewriting the rules of law that are not constitutional law. So get off your high horse and listen to the people, speaking on behalf of the people. That's the point. Yeah, Eric.
Yeah, excellent exercise. I'm glad this was brought up. They've certainly over the decades have corralled another definition of another word into their into their side of the court. Um, and as I think you just said yourself, what I was going to say is that I think we're going to have to start dating this stuff. That's why it's going to be important for us to go through this exercise. That this is the definition we're using, the original definition, before people got their hands a hold of it and started distorting it to favor their particular, industry, the legal
Exactly.
profession.
Yeah, the bar, or absolutely. So I want to acknowledge Ron for all of the things that we have in our documents that cover us and explain what it is that we're doing so beautifully, Ron, where you say we choose the words we use and the means of communication because, just because we haven't put an ad in a public paper announcing that we're an assembly, even though he tried, we have to use communication in means that weren't even known about at the time of the Constitution or the way the assemblies originally were dispersing information about their, like, for example, to this day, when you go into the court to do a legal name change, first of all, they give you a legal name, which is a all caps name. Second of all, you have to post it in the public square, which for them, with the change of time, means on their bulletin board. You have to legally, lawfully post the name change on the bulletin board in the courthouse. So that is considered the town square, whereas it used to be done in the town square, like on a public board. So that still holds, but they have a different format now. Yeah, Cynthia.
So, Black's Law Dictionary, Bridge 5th edition, was actually published in 1983.
Whoa.
Yeah. I knew something, but I'm like, this, because I can't find in this dictionary when its actual publication was. It doesn't say. I just read the preface on it and all that stuff. It does not say. It gives this wide range of publications.
Yeah.
Starting with 1981 or 1891, then 1910, which I would gather is the second edition, 1933 third, 1951 fourth, 1957 fifth, 19, well, I don't know.
I want to read this.
None of that is in mine.
Well, I have a number of dates, and then I have one that says copyright at 1979 by West Publishing. And
Yeah,
I can't really tell which one was actually for mine, but online it says 1983, abridged 5th edition.
abridged.
Not the same thing?
Yeah, abridged means they have abbreviated what the original one was.
Mm-hmm.
Okay, well, wait a minute.
So they're
January 1st, 1979. Hang on a minute.
Oh, here I got 1991,
Oh.
1910, 1933, 51, 57, 68, 79. Then it changed from
Mine was done in 79. Never mind what I said. The abridged was something different, but my actual dictionary was done in 1979.
by West Publishing Company.
Library of Congress.
Yeah, no, those that, remember we did this with the dictionaries too, who the publisher is
Yeah,
and the
by
dates
West
are all
Publishing.
matter.
Yep. Mine was done in 1979 by, yeah. So mine's not even, that's old. I mean,
Yeah, okay, so
there's
mine,
changes all the way through.
yeah, so what's interesting in mine is it goes, because mine is the newest one, the most recent one, and it has a whole line of copyrights. It has Copyright Clearance Center, et cetera, and then it has copyright information. So Black's Law Dictionary is a registered trademark of Thomson Reuters. And then it says registered in U.S. Patent and Trademark Office, which, by the way, I don't know if you know about the patents, but the patents go to England, to Britain, and they are owned by Serco, SERCO, and they use those patents in such a way that they will take them and use them, tie them up so that the people who have the patents can't use them, but they can use them against us. I learned that years ago. Serco owns our
Why
patents.
you want a trade secret and not a patent?
Yeah. Yeah. It's a way of them getting the best of all the new creative ideas, ideologies. And
Patents are people that believe that the government's good for us.
yes, exactly. they they mean to help protect
Yeah.
us and provide us with happiness.
Yeah, right.
Copyright. Okay. So,
Virtually, right? Nowadays it's
yeah.
virtually.
Yeah.
Virtually.
So this one, the latest on this one is 11th edition, 2014. So 2009, 2014, 2019 is mine. So really recent here. Let's see.
Wow.
Okay, well, I think this has gone long and it's been a very productive, wonderful meeting. Thank you, everyone. So I did want to read one more thing. I don't know how you feel. So I wanted to read this a little bit about the unfettered counsel since we're on this subject. And if you have to drop off, I understand. But the constitutions for the United States and Constitution of your state both provide that in all criminal prosecutions, the accused shall have the assistance of counsel for his or her defense. The word counsel is not capitalized in the state constitution. Now, I don't know, we'd have to look in ours. Further, the 6th article of the United States Constitution provides in part, quote, this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, and anything in the Constitution or laws of any state to the contrary notwithstanding. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. To deny the exercise of a protected activity to one rightfully not prohibited or barred by incapacity for exercising such conduct is to do violence to the oath of the office by which such performance is mandated, and dishonoring the service agreement for which all officials are remunerated while serving in the capacity for which they have given such an oath. It is well known that lawyers are officers of the court as a privilege afforded to those who swear allegiance to the bar and are licensed to practice, these are in quotes, quote unquote, before courts, quote unquote, sometimes using the appellation esquire, quote unquote, to distinguish themselves from the laity, quote unquote. By the terms of the Constitution for the whatever state, judges are required to be licensed as lawyers, quote unquote, to practice law as a condition of obtaining said office, and as bar, quote unquote, members are also afforded such privilege as membership in the bar, quote unquote, carries with it, not excluding the title of nobility known to all the laity as your honor, quote unquote. Is it possible that the Bar Association had a least minor influence in drafting the language used to establish such a foundation for the judiciary, or perhaps just enough influence on the, quote, model constitution, end quote, from which this, quote, progressive idea was obtained to support such a monopoly in a, quote, free state? It is axiomatic that a grant of privilege results in a reciprocal, quote, duty to the, quote, grantor of the privilege. Such privilege and duty converts to allegiance in circumstances of conflict of interest, as when a contract of employment with appointed or hired defense lawyers conflicts with the, quote, bar policy, reducing the contract to that of secondary importance. Corpus juris secundum. I remember that was something Dave wrote up and submitted under attorney and client. Given the duty of a recipient of a privilege to the provider of the privileges, it is likely that the representations of the bar counsels, in quotes, are at least as likely as not to be biased in favor of the bar when the question turns on which affects the members in the negative. Given that I do not choose to be adventuresome in respect of my liberty, I have decided to exercise the only available alternative and prosecute such defenses as is practicable, given the prevailing conditions. So, and then this is to be signed by said attorney. Refusal to contract with the accused as an attorney and counselor in law. They're supposed to sign this. I, so-and-so, being an attorney and counselor at law, do hereby sign this notice confirming that I will be unable to provide assistance of counsel as secured in the Sixth Amendment and the Judiciary Act of 1789, Section 35, to the accused. And further, I will not disclose the reasons for being unable, refusing to provide assistance of counsel to the accused as secured in the Sixth Amendment and the Judiciary Act of 1789, Section 35. I have not attached to this refusal the reasons why I'm unable to provide assistance of counsel as secured in the Sixth Amendment, So what's interesting that's happening on Oregon right now, Suzanne Bonamici, criminal, has requested funding for counsel for criminal trials. And it's been on the news repeatedly, and I see your hand up, William, so I'll get to you in just a second, but I want to finish this. So there's a paucity of attorneys available for criminal trials who are not able to have their trials because they're in a holding pattern, because there are not enough attorneys, lawyers to help be counsel to them. And so they're asking for funding so that they can entice more lawyers to be counsel for these criminals, supposed criminals. And this is part of the whole color of law mess in the first place. So they're asking for more money for their fake system to enforce laws against the people with attorneys who are counsel to really the courts, not the people. Isn't that a conundrum? So they're getting more money for their broken fake system.
It's more money to
She's an
steal,
attorney.
is what it is.
Wait a minute, you both spoke what, Eric?
It's more money to steal, is what it is. Anytime the government takes money and sets it aside for something, you know it's going to, a large proportion is going to be stolen, just like the money that's going to the Ukraine. And the same thing is going to happen with that system. Yeah.
Yeah, you're right.
They do not want to let go of this. They do not intend on losing here. and we do not intend giving it back to them.
And then the bullets started flying. And then he jumps out of the car, and he's got both his hands up.
And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, just shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.